quick clarifying question.
Yeah.
We're only talking about like the front end in your research. Is that correct? Am I understanding you correct? As far as somebody got a less than like a 90% loan.
Sure.
More insurance. The pool insurance on the back end, where the initial buyer had no idea that this was being taken out, they were part of the contract and that. Is that the same situation on the back end mortgage insurance policy?
My personal belief is that that mortgage insurance company can go after the borrower. To repeat the question, he was saying on these back-end loans that sometimes the borrower doesn't even know that the investor or the bank has gone out there and purchased insurance to protect the investment, that can those insurance companies go after borrowers. And just based on the principles of insurance law and contract law, I would think that they can. Because let's go take it back to the auto accident case where you've got, it doesn't matter who hits me. My bank, my company's, I don't.
But there's a law in that case that everyone's required to have auto insurance. So you're breaking the law. In the case of the MI, it's not a requirement by law that these active insurance policies are being purchased. They're not being purchased at even, the borrower doesn't know they're being purchased. And so, I actually had clients, where they had these back in MI companies come after them for the deficiency on second. There's MI on second coming after them, and there's no, they're not part of the contract. The borrower is not. There's no law requiring that insurance policy to be involved. So it's kind of.
Sure. To repeat it again, is he was talking about, sometimes when it's the second that goes out and has that insurance on the investment. And again, and using the rationale is the auto accident case different because everybody's required to have auto insurance? Well, in my hypothetical, I got hit by somebody that was breaking the law. So, that's sort of why it's out there. The other is that just under subrogation, that's these insurance companies, that's how they're making their money, is sometimes they're going to have to pay a claim, sometimes they don't. And so if you've got a situation and maybe the borrower has a defense to that claim by saying, I didn't know about it, it wasn't commercially reasonable for you to do that, you didn't need to do that, they can assert those defenses against the insurance company. But I don't see, just on the surface and on the concept, how there would not be a claim by the mortgage insurance company against the borrower. That they should, just under the principles of subrogation, be able to do that, even if the borrower didn't know about it. And I'm like you, I'm hearing about it more and more happening where the borrower, for example, closes the short sale and doesn't even know. So that's going to raise the other elephant in the room that is becoming one that people need to talk about at short sale closing, is that you just need to find out, is there mortgage insurance? These lenders will tell you. There are some blogs out there that actually, I'm laughing because I chuckle at this, they suggest that you as realtors contact that mortgage insurance company and negotiate. I think that you're doing enough probably already to try and get these deals to close, but if you ask that lender, and you can document that you've asked that lender, is there mortgage insurance, and if they tell you no, or they don't disclose that to you, you're probably going to have a pretty decent defense in a future deficiency claim. If you do know that it's there, then again, it's going to be just like the figuring out, having that short sale settlement agreement specify what's going to happen with the deficiency, have it specify what's going to happen with the insurance, or at least it's another layer that you can talk about. On the topic of mortgage insurance, something else that I heard about that is starting to also evolve is once the mortgage insurance company starts getting involved, because they are now inserting themselves into the short sale approval process and having to approve short sales, they are sometimes going to people and saying, I want $7,000, but I don't want it to show on the HUD or on the closing statement. Now, I just heard about this, so, and we can talk about sort of the ethics of that, but that's probably not going to get us very far. It probably is illegal for them to do that. Can people pay funds, money's outside of the closing? Yeah, probably. But it's one of those topics that may or may not be true. I just heard it in a similar class. Somebody said they had just experienced that. So I have no reason to doubt that that did happen to them. just something to be aware of. But I am going to talk really quickly about my last emerging issue, which is discharging gosh, that's hard to say sometimes, discharging short sale promissory notes in a bankruptcy. And how this topic came about is that about, I don't know, 6 weeks or so ago, somebody in a similar class said, I heard that there's a new rule in the Oregon bankruptcy courts that they will not discharge a promissory note that is signed at a short sale closing. And first, it's kind of like, well, no, courts don't just issue a rule and apply it to everything. It's on a case-by-case basis. But it was interesting because there were enough people in that room that the buzz started and people started talking that about 3 weeks later, it was gospel at that point, that in Oregon, that you could not discharge a short sale, a promissory note signed at closing in a short sale. And I think that you probably all know that at that 11th hour, exactly what Larry said, is people are being surprised because guess what? They're being asked to sign a note at closing in a short sale. So this is another one of those topics that I thought, well, let's get to the bottom of this because it's just not making sense. I talked to a number of my bankruptcy colleagues here in town that do filings for people, so they're in the trenches every day, and I said, are you seeing this in Oregon? And they said no. And I haven't read any cases in Oregon, and it's not happening in Oregon. Took it a little bit further and I did some more federal research, and without boring you on the details of it, there is one case out of New Mexico from October of 2009, and in that case they discharged the note, but I'm going to tell you a little bit about it because I think it's indicative of where we might be a year from now or 6 months from now. In that particular case, the borrowers had a first and a second, and on the second, the second was starting to put some pressure on them, and maybe they had a judgment. I don't know New Mexico's collection laws. Maybe they were doing some harassing things. I have no idea. But they basically said to the second, hey, please don't bother me anymore. I'm closing a short sale. I need to get this behind me, but then I'm going to make good, and I'm going to pay you. So the second position lender said, okay. And so they quit harassing them. Short sale closes and the people file bankruptcy, and they're now trying to discharge the unsecured note because that deed of trust has been torn up. So what happened in that case is the bank was an aggressive lender, and they filed a complaint to deny discharge of that obligation that was owed to that bank. And the court looked at all of the information and granted a judgment in favor of the borrowers in that case and said, yeah, there is a rule that talks about false pretenses. You can't get money or you can't incur debt with false pretenses. And what was very important to the court in that case was it was an existing loan. That all the bank had done was forego kind of their collection right, but they really weren't out any more money than they'd been out before. So they said, sure, they might not have intended to ever repay you after a short sale closing, but you really weren't harmed. You weren't going to get anything anyway, blah, blah, blah. The key in that case was there was no new money. So what happens when you get that 11th hour request to sign a new promissory note in order to close a short sale transaction is, guess what? You've torn up the old promissory note and now you have new money. That doesn't necessarily mean that it's not going to be dischargeable in a bankruptcy. It just means be careful as realtors because you will probably be called to testify in these cases, and so will the people at the title company. What did the borrower say to you? Did they sign it by saying, I'm going to stick it to this bank and, I'm just going to turn around and file bankruptcy tomorrow? If you've got testimony like that discharge, I can see it very likely ending up not being discharged in a bankruptcy, that second promissory note. But if instead you're in a circumstance where, I'm going to try and I just need to get out of it from under some of this debt, I can probably service this debt, and then they eventually find out that they can't and they file a bankruptcy, vastly different circumstances because the lender is still going to have to prove false pretenses. So what started off as a rumor became a gospel truth, actually has no truth whatsoever, but is definitely under the topic of emerging issues, and I think that we in Oregon are going to see this in the next year. So just be careful, and I know it's tough out there to close these, and many of you are probably very willing participants in short sale market, but that's what there is out there, so we'll all just make the best that we can of the circumstances.